Welcome, aspirants. Welcome to another high-yield explainer session right here at Rungta IAS Academy. Today, we've got a really critical analysis lined up, and it is perfectly mapped to your General Studies Paper 2 syllabus. We're diving straight into polity, the judiciary, and your fundamental rights.
Absolutely. Today's source material outlines the Supreme Court's latest stance on that old colonial offense of sedition. In this session, we're going to decode the exact coerced consent argument. This is a concept you absolutely need to integrate into your main's critical evaluations.
So here is our quick roadmap for today. We'll map sedition to GS2, track its evolution from 124A to the BNS, look at the Hobson's choice facing the accused, examine the justice and wealth divide, and finally tackle the mains and interview applications.
All right, moving to Section 2. Let's look at the evolution from 124A to the BNS.
It's absolutely crucial we lay down the factual, historical foundation first. Back in May 2022, the Supreme Court halted 124A FIRs and coercive measures pending a constitutional challenge. This happened in the landmark case of S.G. Vombatkare. Make sure you've got the pronunciation down for your interviews. That is Vombatkare versus Union of India. Fast forward to 2024, and the Bharatiya Nyaya Sanhita, Bharatiya Nyaya Sanhita, takes effect. It replaces 124A with Section 152. Practically, it's sedition by a new name, but with an increased minimum sentence of 7 years. And now, jumping to May 2026, the Supreme Court clarifies that trials can proceed, but only provided the accused person has no objection.
Section 3. The accused Hobson's choice. This brings us right to the core of the issue. This May 2026 clarification by the Supreme Court, it is highly problematic for under trials. I want all of you to highlight this exact phrase in your notes right now. Hobson's choice. It is essentially an illusion of choice. An incarcerated person has to pick between two terrible outcomes. Either move forward with an unfair trial or face an indefinite delay just sitting in jail. Look, when an accused lacks robust legal representation, this so-called consent to face trial isn't consent at all. It is effectively coerced.
Exactly. And this brilliantly illustrates a stark contradiction in our legal framework. The fundamental legal principle is that bail is the rule, and this was very recently reinforced by the court in Syed Iftikhar Andrabi. Mark that citation down for your answers. Syed Iftikhar Andrabi. You see, the 2022 Vombatkare stay was intended for those charged to move for bail. Liberty was supposed to be the remedy for frozen trials. If the court really wanted to preserve the agency of the accused in 2026, it should have paired the continuation of these trials with a strict presumption of bail. But instead, this May clarification swings in the complete opposite direction.
Moving on to Section 4. The justice and wealth divide.
Aspirants, pay close attention here. If you get a 15 marker on contemporary judicial issues or fundamental rights, bringing in this specific socioeconomic contrast is basically mandatory for top marks. The harsh reality on the ground is a stark divide. On one hand, wealthier or politically connected accused persons can secure bail through sustained litigation. They have the resources to just wait out the proceedings outside of prison. But on the flip side, poorer prisoners who can't secure bail are compelled to consent to a trial just to obtain a verdict and potentially walk free. The result? An individual's liberty has become completely dependent on their capacity to litigate rather than on constitutional legal principles.
And that brings us to Section 5, our final and most critical segment, mains and interview application.
How do we tie all these systemic consequences together for the examiner? Remember these three major points. First, this framework creates a perverse incentive for bad faith state actors. They know that cases involving constitutionally contested offenses can just sit in limbo while the accused remain incarcerated. Second, because of this, the state easily avoids resolving the underlying legal uncertainty quickly. And third, by approaching the issue this way, the judiciary is effectively declining its own duty to determine, once and for all, if sedition as a criminal offense is actually constitutionally sustainable.
Let's close this explainer with a direct prompt for you to think about. Instead of deciding if sedition is constitutional, has the Supreme Court passed the burden to the accused? This is a classic UPSC personality test question right here. I want you to take the structured framework we've discussed today, analyze the source material, and confidently formulate your own stance. Thank you for joining us for this explainer, aspirants. Keep your preparation focused, keep revising, and we will see you in the very next session.